my focus is going to be on the challenges that African countries face in exercising their rights to use the flexibilities, the public health flexibilities under the TRIPS agreement. Now, many of you will know that for almost 3 decades, access to medicines activists and advocates have championed the use of TRIPS public health flexibilities in order to overcome the IP monopolies that have priced medicines and other health products out of the reach of a majority of the global population. One of the key public health flexibilities is, in fact, the one that we're dealing with, compulsory licensing, and I might add government use licenses. As many of you will know also, that the compulsory license flexibility is actioned when a government grants an authority to a third party. It could be a generic manufacturer to, in fact, use and manufacture the invention that is covered by the patent. And in the case of a government use license, it is the government giving this authority to itself. So that's just by way of distinguishing those two. I'm going to start by presenting some evidence on how the flexibilities have actually been used in Africa. And what I've done in the left column is to identify the key flexibilities that have been used by type, in other words, what kind of function do they serve. And then, of course, I've got on the right-hand side the number of uses of those flexibilities that have taken place in Africa. I might just say that this information is also part of a larger study that actually looks at compulsory licensing and other flexibilities use more sort of globally. But I think we could just say that the patterns are very similar in that the use of the flexibilities have been somewhat limited. Now, while that number 72 at the end there looks like a lot, let me sort of explain some of the context. Okay, so what we have found in searching the various databases that actually record how often flexibilities have been used, that the so-called compulsory licensing and government use flexibility has been used by African countries on 29 occasions. And here we're looking at the period from about 2003 to probably the present, or the information we have is up to 2019. So that's, a sort of 16-year sort of span. So compulsory licensing was used 29 times. And of course, that's not a lot of times. The second flexibility that I've highlighted there is what is known as the LDC pharmaceutical waiver. This is a flexibility which enables least developed countries to not apply the pharmaceutical patent protections for an extended period of time as a transition flexibility that they allow. Right? So these are in Africa. There's some 33 countries which fall into this space. And because they're LDCs, they don't have to recognize pharmaceutical patents, and they could go ahead and import them and so on without infringing patents, without breaking any laws. We had 41 uses of this particular flexibility in Africa in the period that I mentioned. Then the third one is the parallel importation flexibility, which has been used once. And then that was in Kenya. And then, of course, the competition-based flexibility. In other words, using competition law and policy to access medicines. That was used once, and that was in South Africa. Well, there were a couple of cases, but it was used in South Africa, again, in the mid-2000s, when complaints were lodged with the Competition Commission that the pharmaceutical companies had been engaging in what is known as excessive pricing. So that's the type of flexibilities that have been used and the number of times they've been used. So let's do a quick analysis of this and see what it tells us about what's happening here. So what we're able to tell by looking at the 54 countries, that some 41 countries have used some form of flexibility over this period, right? So not everybody has done it, right? As I indicated, there have been 72 uses of the flexibilities. In other words, flexibilities have been used 72 times by those 41 countries. And some countries, of course, have used it multiple times, and others have used the flexibility just once. The numbers there are all, I've already repeated that. But what's interesting here, if you look down the second bullet point and then the sub-bullets, number 5, which says 70 of these 72 were flexibilities were used in the period 2002 to 2009. Now, of course, it's very easy to understand why that was the case, because this was the time when we've had the peak of the HIV/AIDS pandemic, and that, in fact, the need for antiretrovirals, as you know, because of the exorbitant pricing by multinational companies, made them inaccessible and unaffordable, then gave rise to the need for compulsory licensing to be able to access generic medicines. The significance of this period also lies in the fact that this, and as I say down in the next bullet, the bulk of these applications for compulsory licenses or use of the LDC transition were for antiretrovirals. And what's significant here is that it was during the period window before the Indian Patents Act of 2005 came into operation. So what we had happening here was that up to 2005, India was allowed to continue not recognizing product patents, and therefore they were not infringing if they copied and produced those ARVs and they supplied it to other countries. And this was when I think we had the maximum use of these flexibilities. Of course, come 2005 and the new Indian Patent Act coming into operation, it put a brake on the quantity and the range of generic production that was actually possible. And in fact, now all the newer drugs were patented, and it was not possible for them to easily make use of that. Compulsory licenses would have to be sought, and of course, those came with their own set of problems. Also important to note is of the 33 least developed countries in Africa, only 25 of them have used the LDC waiver flexibility. So you'll find that in the laws of many countries, which are least developed countries, they have actually provisions that protect patents, even though they're not required to by the World Trade Organization, by the TRIPS agreement, right? So, I mean, this is part of the historical problem that I would talk about in a moment. It's also important to note that the flexibilities have not been used in Africa since 2014. The ones that I mentioned, as I said, were in that period, 2002 to 2009, 70 of them. And then in the 2010-2014 period, just 2. That's very interesting. We're in South Africa, and there's a lot of focus on South Africa. So I think it's fair to say that the study that was mentioned in the earlier presentation, we were involved in that, and what became very clear that although South Africa has had legislation that allows compulsory licensing to take place in over more than a century, because we've had the first provisions in the early 20th century, in more than 100 years, there has not been a single compulsory license granted on a pharmaceutical product. Right? This is not because applications have not been made. It is because of a number of issues, which I can move on to just now. So maybe then just trying to unpack why we've had such a limited use of these. This is a very important option that countries might have. And of course, why also do countries not include these flexibilities in their legislation? Why haven't they reformed their legislation as South Africa is proposing to do? We hope it will be done soon. And why do they not use them even when they are in the law? I think that's got to do with two kinds of challenges. One is what I call a sort of historical challenge, and the other, the sort of more contemporary challenges. So the historical challenges, I think, lie in the fact that the intellectual property legislation, including the patent laws of most countries in Africa, if not all, are a product of their colonial history, right? They were colonies of the European countries, and they sort of willy-nilly adopted the IP laws of these countries, and they had to apply them. Because, of course, the purpose of the colonies was basically to serve the so-called metropole. So the very architecture of IP laws is such that it makes it very difficult for them to be used. The design is essentially to protect rights holders, and very little attention is given to the rights of the public and people who have to use, coming back to Rodrigo's point about also they enjoy the fruits of the advancement in science and technology and so on. And the more contemporary challenges, I think, relate to what situations that we have at the moment. For example, the lack of expertise of skilled people, the lack of a substantive examination system, which requires, the employment and training of a range of experts who are able to process these applications. South Africa does not process these applications. That figure that we produced in the study of 2,442 patents in 1 year was simply because South Africa does not examine patents, and anything that is deposited as an application gets approved. So I think many of you in South Africa will identify with this. It seems like it is easier to get a patent in South Africa on a medicine than to renew your driver's license. But I'll let Leslie inform you about that. But also the resources that are needed to maintain that kind of system. So I think those are some of the more structural difficulties that countries have and challenges that they face. Compulsory licenses are notoriously difficult to use. Firstly, you have to have a prior negotiation. Of course, there are some exceptions to this if you're using it for public non-commercial use in the case of a government license. But there has to be a prior negotiation between the say, generic company who's applying for it and the holder of the patent, right? And of course, it's got to be done on a drug-by-drug, case-by-case basis. So this is a very long process. And usually, the negotiations, as you know, in most negotiations, they can be stalled by a party that is not interested in finding a solution. And this is generally what happens. So this is the first obstacle. The second set of obstacles in using compulsory licensing is what are known as patent thickets, or in other words, the whole collection and maze of patents that may be applicable to a particular product, right? Often it's not just one or two, it runs into multiples and sometimes even hundreds of patents on a single set of product. So for a competitor to unearth that and to know that is a huge mission. It requires a lot of resources. And of course, there are other protections as well. There may be protections, as we are discovering now, that are covered by trade secrets or copyright or industrial design, or and a number of other IP protections as well. So all of these things have to be negotiated. There are trade and political pressures on countries. There's a lot in the literature about how South Africa, Brazil, Thailand got punished by high-income countries and the pharmaceutical industry for attempting to pass to approve compulsory licenses. There's the problem in Africa of the regional intellectual property organizations, which are not really fit for purpose. There's literature on that issue as well. There's the problem of political will. Governments are not keen to challenge the status quo in many cases. We often wonder why our government is so tardy in passing the reformed Patents Act. And then there's issues like judicial deference. So, for example, lawyers will be particularly interested in this, is that another study that we had conducted looked at compulsory licensing, why we haven't had that in 100 years. And what we found was that in addition to the very colonial architecture of the laws, the judges, the bureaucrats who are trained to adjudicate these patent disputes and so on, have a mindset which is really steeped in that particular culture, and it's steeped in protection of the holder's rights and has no conception whatsoever of public interest in these kinds of matters. And this is not only in the apartheid era, by the way. We've had recent cases in the constitutional era where they have actually not applied constitutional imperatives successfully. So that's again something that we can deal with in questions and so on. So now, just to probably conclude, reference has been made to the waiver, and I just want to sort of point out that quickly, the position of South Africa, India, and the 100 countries that have supported the waiver is simply because what the waiver can do is, it's not a magic bullet, but it can, through a single action at the World Trade Organization, result in what we might have to achieve through hundreds of actions in different countries applying for compulsory licensing and so on. So that's the one big advantage. It will provide a blanket suspension of all the relevant IPs for the duration of the waiver. And it also provides legal cover against being hauled to the WTO on their dispute settlement provisions. So this is the kind of protection that the waiver would give. On the other hand, and this is why, of course, the reasons for which South Africa and India proposed that waiver are fairly clear: the crisis of the pandemic, the fact that there's a shortage of supply, the fact that although there are multiple producers throughout the world who can manufacture, whose facilities are lying idle, the pharmaceutical industry refuses to share its know-how to enable this to actually happen. Now, the European Union position and the pharma position, and of course, this is usually the position of rich countries, is that IP is not a problem. And they, in support of that, they say, well, you see, we delivered so many vaccines in record time in 1 year and so on. But I think, as others have indicated, they did not deliver that alone. It was achieved largely through the tremendous collaboration by scientists, firstly, but also the enormous amount of public funds that accelerated the vaccine production process. They say that IP protection is necessary for further innovation. We know that what we are seeing before our very eyes is an orgy of profiteering. You'll see that there's already 15 new billionaires just in 1 year alone as a result of the profits that are being made by Moderna, Pfizer, BioNTech, and other companies. And then we have the very cynical position by the EU and the pharmaceutical industry that the existing flexibilities are sufficient to improve access. So I say it's cynical, it's ironic, it's criminal almost, because these are the very forces, right? Those countries, those industries that have provided obstacles to the use of these flexibilities. So now saying, well, why don't you use those flexibilities? You do not need a waiver. So I think that's the level of hypocrisy that we've actually got in terms of the way rich countries have been playing out this particular game. But I'm going to stop there and happy to take any questions. But I thought I should end with that note that the waiver is necessary for all of these reasons, mainly because the existing system is broken and it has failed the poor people all over the world. Thank you.